So last week's lecture was quite difficult. I got many questions. So I have prepared 2 slides which will help you with your revision. Please be careful because adult guardianship, etc. is a topic which is quite interesting for the final exams. I like the diplomatic way in which I talk. Interesting for the final exam. I like it so much. Okay, so we have 3 categories: adult boards, persons under curatorship, and persons under assistance, according to last week's lecture. First question I received from many students. We did not understand the difference between these 3 categories. So, let's start. Adult wards is the category where the situation of the person is quite grave. If you have a look at Article 7 of the Civil Code, it says constantly, please underline, constantly, lacks the capacity to. So, here we have a constant situation. For example, it could be a person with Alzheimer of a quite heavy level. Second, persons under curatorship. If you have a look at Article 11 of the Civil Code, you can find the provisions in last week's material. If you have a look at Article 11, it says capacity is extremely insufficient. What's the difference? It's not constant. So there are some occasions where you can have conversations with the person when he or she understands what is happening, but his or her capacity is still extremely, so please underline extremely, insufficient to. And finally, persons under assistance. If you have a look at Article 15 of the Civil Code, it says has insufficient capacity to. So it's not constant, it's not extreme, it's just insufficient. So it could be people with mental issues, mental diseases, for example, who most of the time can understand what they're doing, but there are some occasions in which they cannot. So, adult board is the most severe situation, the middle situation would be persons under curatorship, and the most light situation would be persons under assistance. Second question I received also from many students. Okay, we understood the difference of the categories. Now, what's the difference in the treatment of each of these categories? Answer. If you have a guardian of adult, so if you have a person who is taking care of an adult ward, he or she has the right to rescind. I have received also many questions regarding the word rescind. Is it the same with terminate, for example? Answer, yes. So in Japanese, it's torikesu, torikeshi. In English, I would prefer the word termination, terminate. But the translation of the Japanese Ministry of Justice uses rescind, so I'm going to use rescind too. So please remember, it doesn't have to do with consent. No. The guardian of an adult can rescind all acts except for the daily life purchases, etc. And he or she has also the right to represent dairi, which means that he or she can conclude contracts on behalf of that person. So you can see that the powers of a guardian of an adult are quite strong. Let's move to a curator. A curator has the right to consent and rescind for 9 types of act. Where did these 9 come from? If you have a look at last week's material, Article 13, you will see that in paragraph 1, it mentions these 9 types of act for which the consent is required, and for which, if there is no consent, the curator has the right to rescind. So please be careful, it's not all contracts, all acts, as in the case of the guardian of an adult. It's only 9 types. And if you have a look through these 9 types, you will see that they are some important contracts or juristic acts. And as you remember, it depends on what actually the person under curatorship did. For example, if he sold the book, which is worth only 10,000 yen for 100,000 yen, then the curator will not rescind. He will say, bravo, please do it again next time. Finally, assistant. So, in cases of assistance, we have the very light situations where the person usually can't understand what he or she is doing, which means that, please be careful, the right to consent and to rescind of the assistant is optional. It means that it doesn't automatically mean that when a person is under assistance, his assistant has the right to consent or rescind. It depends on the case. He might have these rights, he might not. If he has the right to consent, which means that he also has the right to rescind, please be careful, it will be only for a part of the above 9 types. So, it cannot be for all 9 types. That's the provision of the Civil Code. So you can see that the rights of the person who assists, who supports, are gradually restricted. Now, what happens with the right to represent? I told you that a guardian of an adult has the right to represent. He or she can conclude contracts on behalf of the adult ward. Answer. As you can see at the bottom of this slide, the right to represent is optional for both curators and assistants, which means that, again, it depends on the case. They might have the right to represent, they might sometimes not. Finally, I told you that assistance is a situation where the mental disease, mental distress, etc. is very light, which means that, as you can see again at the bottom of this slide, if the assistance starts with a requirement of another person, so it's not the person in question who asked for this, it's maybe his wife or another person, then we need to have his or her consent. So the court will ask him or her, do you actually want to be under assistance? If he says no, it's a no. So you can see the difference in the treatment. You don't have this in cases of curatorship or in cases of another ward. Any questions? This is quite important. I think that now you have a more clear picture of what happens. do not hesitate to ask me right now. Okay, you need the microphone. Yes, could you please? Thank you.
Okay, so just to clarify, for the curator, it is the right to consent is not optional for the adult, but it is the right to represent is optional.
Okay, so Calvin, yes, that's an excellent question. The answer is yes, you're right. So, the curator always has the right to consent for the 9 types mentioned in Article 13, so it's automatic. If a person is under curatorship, his curator has the right to consent for these 9 types. How about representation? It's optional, so it depends. One more question, maybe? Okay, so Matthew.
Just quickly, is this for solely mental, or does it include physical as well?
That's an excellent question too. So, let's have a look at last week's material. Do you, don't have it there? Okay, yeah, so, Calvin, you are the closest person to me. Could you please come here? So, I have last week's material. I will ask you to put it. I forgot. I was in a hurry. So, please raise your hands if you need last week's material, or he will just put it there. Okay, just put it there, Calvin, David. Yeah. So, Matthew, let's have a look at last week's material. If you don't have it, it's there. See. For example, let's have a look at Article 11. For example, okay? It talks about curatorship. And it says, with respect to any person. So Matthew, could you please read the first 2 lines of Article 11 of last week's material? Yeah, it's on page 2, Civil Code. Oh, could you please use the microphone?
With respect to any person whose capacity is extremely insufficient to appreciate right or wrong due to any mental disability.
Thank you. So, you can say that the provision says due to mental disability. Now, let's move to Article 15. Could you also please read the first 2 lines?
With respect to any person who has insufficient capacity to appreciate right or wrong due to any mental disability.
Thank you. So you have the answer in the provision. It says mental disability.
No, I remember that. It's just that the right to represent is also useful in cases where there's physical incapacitation.
Okay, so that's another question. You could have an agreement between them which gives another person the right to represent, etc.
But they wouldn't be an assistant,
No. Because all these 3 categories, according to the provisions of the Civil Code, are limited to cases of mental disabilities. Okay.
Are there separate provisions for physical?
No. So it will depend on a personal agreement, etc.
Okay.
And the reason why is that, as you might remember, these 3 categories, so this system, so who remembers? I will give you double marks. It's a question. Why do we have these 3 categories? What are we protecting with this system? If you answer the question, you will get double marks. Matthew?
Well, I'm assuming it's to project some Zeisan property and...
Excellent, thank you very much. So, as Matthew told us, yes, this system, the aim of this system is to protect the property of these persons, not themselves. Which means, in other words, that if they don't have money, they don't need to do this. For example, if you have an old person who has Alzheimer's and he might conclude very dangerous contracts, If he doesn't have any money at all, there is no trouble, because he's not going to lose anything. Okay, we could say. So, yes, this system has to do with the protection of the property. That's why in cases of physical disabilities, we don't have such a system, because people with physical disabilities can still judge if they should conclude the contract or not. Okay. Any other questions? Is everything clear now? We hope so. No, I don't hope so. You should hope so, because I'm not going to sit for the exams anyways. So, today's topic is family and law, which is very interesting. I like this subject. I could do 15 lectures about this, but unfortunately we're going to have only one lecture regarding this. So, we will start with family, the beginning, family, expansion, and or enlargement, and family, the end. We'll see 3 stages. If you're interested in marriages, divorces, which are very interesting topics, you can take my lecture during the 2nd semester, because there we are going to talk about marriage, divorce, etc. Stages that maybe most of us will at some point of our lives, maybe, okay, I said maybe, experience. Let's start with the beginning. Usually, when we talk about the beginning of a family, we talk about marriage, which means that I should talk to you about the requirements of marriage, etc. But I'm not going to do that. I'm going to do that during the 2nd semester. This lecture is called Law and Culture. So, we'll talk about something which has to do with the Japanese culture. For example, a question many foreign international students ask me. I have also been asked this year by Matthew about this. Does Japan recognize same-sex marriage? That's the most debated issue in all countries, maybe, regarding marriage. So let's see what happens in Japan. Let's start with the Constitution, because the Constitution is the most important law in Japan. Who would like to read Article 24 of the Japanese Constitution? Okay, thank you, so Chisaki.
Should I read both the top and bottom?
Yes, please.
Okay. Marriage shall be based only on the mutual consent of both sexes, and it shall be maintained through mutual cooperation with the equal rights of husband and wife as a basis. With regard to choice of spouse, property rights, inheritance, choice of domicile, divorce, and other matters pertaining to marriage and family, laws shall be enacted from the standpoint of individual dignity and the essential equality of the sexes.
Thank you. So, according to this provision that Chisaki just read, marriage shall be based only on the mutual consent of both sexes. And that's all. So, you can easily guess that the largest part of the debate regarding same-sex marriage in Japan focuses on the meaning of mutual consent of both sexes. Some academics, some people say that it says both sexes, which means that in case of a marriage we have a man and a woman. Other people say no. In the past, when we had the Meiji Civil Code, that's the civil code, as you remember, prepared by the 3 young professors, which has been revised, so it's partially different from today's civil code. Under the Meiji Civil Code, in order to get married, you needed to have the consent of the head of the family. Who's the head of the family? It might be your grandfather, if he's alive, or your grandfather, etc. Plus, if you were a man under 30 or a woman under 25, you also needed to get the consent of your parents, additionally. So, some people say this provision of the Constitution shows that Japanese society has changed. You don't need the consent of others. Marriage has to do with the consent of the two parts who don't need to be of a different sex. So both sexes is not so important. The important part is that marriage is based only on the mutual consent. So if you think in this way, then yes, the Japanese Constitution allows also for same-sex marriages. The debate is very detailed. So now you can understand if, for example, on Twitter, you can see some lawyers saying it doesn't say that the two persons need to have a different sex, etc. Now you can understand what they're talking about. Now, people who say that the Japanese Constitution allows for same-sex marriages also use Articles 14, Paragraph 1 and 13 of the Japanese Constitution. Who would like to read these two articles? Okay, could you pass the microphone? Could I have your name again?
Eileen, EILANXIE.
Okay, so it's Eileen?
Yeah.
Okay, so Eileen, could you read the two provisions?
All the people are equal under the law, and there shall be no discrimination in political, economic, or social relations because of race, creed, sex, social status, or family origin.
Thank you. And Article 13?
All the people shall be respected as individuals. Their right to life, liberty, and the pursuit of happiness shall, to the extent that it does not interfere with the public welfare, be the supreme consideration in legislation and in other governmental affairs.
Thank you. So, Eileen, what are the people who are in favor, who at least understand that the Japanese Constitution does not prohibit same-sex marriage? They say that, according to Article 14, Paragraph 1, all of the people are equal under the law, which means that also people who would like to have a same-sex marriage are equal under the law, which means that we cannot prohibit them from getting married. Plus, they use Article 13, a very interesting provision which says all people have the right to pursue happiness. So we all have the right to try to become happy. This is an interesting provision. During the second semester, if you take my lecture, we're going to talk about this because it has to do also with the right to smoke, for example. If you are in a jail, they don't allow you to smoke. So some people have filed lawsuits based on this article against the state. Smoking makes me happy. And by prohibiting me to smoke, you are infringing my right to become happy, for example. We'll talk about that during the second semester. So, according to this understanding, we have the right to become happy. And if a same-sex marriage makes me happy, then by not allowing me to have a same-sex marriage, the state is again infringing my right to become happy. Now, that's all about the Constitution, the most important law in Japan. So you can easily understand that the focus of the debate is on the meaning of both sexes. What does this mean? Okay? Now, Civil Code. Who would like to read Article 739 of the Civil Code? Yes, please, Lily. Both means, let me have a look at the provision. 739. No, only paragraph 1, please.
Marriage shall take effect upon notification pursuant to the Family Registration Act.
Thank you. So, according to this provision, which is of a lower rank, because as you know, the Constitution is the top law, the Civil Code is a lower law, it's a common law, so it needs to be in accordance with the Constitution. It says that marriage shall take effect upon notification, and now, Lily, could you read paragraph 2? Regarding this notification,
The notification in the preceding paragraph shall be given by document with the signatures of both parties and not less than 2 adult witnesses, or given orally by these persons.
thank you. So, it says that you need to submit a document with the signatures of both parties. So it doesn't say of both sexes, or of a man and a woman, or of the husband and the wife. It's quite neutral. So yes, if you use paragraph 2 of Article 739 of the Civil Code, you could say that same-sex marriage is allowed according to the Civil Code, because it uses a neutral expression. It says both parties. So, where is the issue? What is the biggest obstacle regarding same-sex marriage? Actually, it's the next provision. Article 74 of the Family Register Act. Who would like to read the provision? Thank you. Could you please pass the microphone? Okay, so just could you remind me your name, please? Okay, sorry, yes, Kelsey. Please. Yeah, I think it's page 7.
Okay. Article 74. Persons who wish to marry should submit a notification to that effect, entering the following matters in the written notification. 1. The surname that the husband and wife will take, and 2. Other matters specified by ordinance of the Ministry of Justice.
Thank you. So, in Japan, you have a family register. It's a bit different from other countries. And according to Article 74 of the Family Register Act, when you get married, you need to submit a notification, and you need to include the surname that the husband and wife will take. In Japanese, fufu. So here, it's quite clear that it's a husband and a wife, even if you see the Japanese kanjis, fu and fu. So this provision does not allow, clearly, does not allow same-sex marriage couples to register their marriage. So even if you say that there is no issue with the Civil Code provision, we have an issue here. Now, last issue, please be careful. If we say that Article 24 of the Constitution allows same-sex marriages, then we can say that this provision is against the Constitution. So maybe somebody could file a lawsuit and ask for this provision to be changed or deleted. So you can see how important the interpretation of the Constitution is. So this is the actual situation. Then Matthew asked me, okay, so let's suppose that same-sex marriage is not allowed in Japan. What do these people do? Is there any other way for them in Japan? And he pointed out this. As you correctly told me, for example, in Shibuya Ward, they have a new system. So let's take it step by step. In Japan, as I told you, in the past, in order to get married, you needed to have the consent of the head of the family, and depending on the age, also the consent of your parents. So what was happening was that the man would go to the house of the woman, and he would ask for the hand of the daughter, officially. And if the head of the family, or the father, or the mother would say no, they would just run away. So romantic. Okay? Pack their things, run away, and they cannot get married. Which means that we will have a de facto marriage. In Japanese, naien, or jijitsu. So, in Japan, de facto marriages were quite a common practice. Why? Because we had this. So if somebody says no, it's your only option, but you cannot get officially married, so you get unofficially married. So we were having many couples who were not officially married, but they were living together for 40 or 50 years. They were having children, grandchildren, etc. So it would be unfair, for example, when we were having inheritance issues or pension issues, etc., or insurance issues, to say, no, you're not married, so we're not going to treat you as a couple, official couple. So, many court decisions provided for a protection of de facto marriages similar to official marriages. And many court decisions provided for a protection of same-sex couples, not marriages, similar to that of a de facto marriage. So there are many court decisions which would say, yes, you are a same-sex couple, of course you cannot get married, but you have been living together for 30 years like husband and wife, so we will provide you the same protection as we do for non-same-sex de facto marriages. However, some people say this is a very big trouble. Why? Because that's the main reason why the state does nothing about same-sex marriages. So the state knows that, okay, the courts are providing for a certain protection, so maybe that's enough. Maybe. Okay? Second option. Adoption. What's that? Let's have a look at the provisions regarding adoption. 792 to 801. If you have a look at 792, it says that a person who has attained the age of majority may adopt another. So if you are 20 years or more, you can adopt another person. Then, 793. You cannot adopt a person of greater age, which means that you can adopt a person of younger age, even if he or she is 1 or 2 months or 1 or 2 days younger than you, which means that this can be used by same-sex couples. The older can adopt the younger. Then, there is no other provision which prohibits adoption between same-sex couples. If one party of a same-sex couple adopts the other, of course they are not officially married, but they have officially the right and the duty to care for each other, inheritance rights, etc. So they know that, okay, we don't have the same protection, we are not a married couple, but we have some legal status, some legal protection. So this is, we could say, an alternative. And as Matthew pointed out, of course, the best alternative For example, in France, they have the system PACS, P-A-C-S, which is a registered partnership. It was quite interesting because a month ago, a professor from Luxembourg visited us. She came with her husband, and a Japanese professor who is not so familiar with the European tradition and practice asked her, "So, the two of you are married?" Which is a common question in Japan maybe. And she said, "Yes and no." So he was like, "What?" And she told him, "We are a couple registered in France." And he was quite lost. So he asked me, "What does that mean?" So I told him, "Well, it's the same like marriage, but maybe you should not ask foreign people if they're married or not, because the issues are not as clear as in Japan." So, in Japan, we could also have a partnership. And as Matthew told me, some local authorities, starting with Shibuya, now there are many, 10 or 12 I think, yes, they have the system of partnership certificates or partnership affidavits. But, so this is a sample of a partnership certificate. It says that the persons mentioned above are in a partnership relation according to Article X of our local ordinance. So it's not a law, it's an ordinance of the local authority. The issue is that this does not have to do with the issues of civil code, inheritance, right and duty to take care, etc. It does not affect those issues. So question, where do they use this? Two examples. Let's say that one person of the two parties of a same-sex couple has an accident and he gets into a hospital and he is in a critical situation. His partner wants to meet him, but officially they're just friends. Of course they are a couple, but they cannot prove that. So they can prove it. They can show this certificate to the hospital and say, "We are family, so I have the right to meet him." You cannot prohibit. Second, some local authorities have public apartments which provide for housing at a lower cost. But sometimes there is a requirement which says that you need to be married in order to apply. They're not married, which means that normally they cannot apply to live in such public apartments. But now they can in these local authorities. They can submit this certificate and they are treated in the same way. One issue, these ordinances are not compulsory, which means that the hospital can still say, "Thank you, but you're not a couple, you're not officially married, so we're not allowing you." I think in all local authorities, they say that they will make public the names of the companies which do not respect this certificate. So that means that that hospital will have its name made public somewhere with a note that, this hospital did not accept this certificate. But it's not compulsory. So companies, etc., can still say, "No, we don't recognize this." Any questions regarding this part? Yes, Matthew?
Just a small one about de facto marriages. As you said earlier, the koseki is the main obstacle in this. With marriages to someone not of Japanese descent, they can't enter the koseki historically. Therefore, would they be counted as de facto marriages as well?
Thank you for the question. So I will try to answer it briefly. I will tell you what happens with my Greek friends who get married to Japanese ladies. So I have many friends, Greek male, who have got married to Japanese women. The woman is the head of the family. So, until marriage, she belongs to the family registry of her father. When she gets married, she leaves the family registry of her father. She has her own registry, and the foreigner is registered into that registry. So she is the head of the family officially. So the issue is that the foreigner cannot become the head of the family. He cannot have his own family registry. He belongs to the family registry of the wife. Okay? Any other questions? Excellent. So, Chisaki, is it too early for the break, or would you like to have a break now? Okay, let's have a break now. Thank you. So 5 minutes break. If you have any questions, feel free to ask me.
I just didn't. No, I didn't. I can't remember his name right now. I can't remember his
So maybe that's you can have
I'm here. I'm still here. Oh my god. Oh my god. Why are you smiling? And then
So let's start again with our lecture. If at some point you feel that I'm talking too fast or the content is too difficult, you just raise your hand and you say, you talk too much, stop, slower. Okay, you can do that. Okay, I will not get mad at you. Now, part 2 of today's movie, family enlargement. So, you get married, then usually you desire or you actually have children. So let's talk about this issue. In Japanese, we have the word jishi, which in English is translated as biological child. And as you remember, we have a child in wedlock and a child out of wedlock. So if the father and the mother are married, it's a child in wedlock. In Japanese, jaku shutsushi. If the father and the mother are not married, the child is a child out of wedlock, so it's hi jaku shutsushi. Who would like to read Article 772? Yes, Chisaki. So, Chisaki, congratulations, you reached the maximum for a 5th consecutive week. They should be applauding, but it's okay. Okay, so yes, please.
A child conceived by a wife during marriage shall be presumed to be a child of her husband. A child born after 200 days from the formation of marriage or within 300 days of the day of the dissolution or rescission of marriage shall be presumed to have been conceived during marriage.
Thank you. So here we have a presumption, which means in Japanese, suite. If a child is conceived during a marriage, it is presumed to be a child of her husband. Which means that if the wife gets pregnant during the marriage, that child is presumed to be a child of the husband. So it's a child in wedlock. It's their child. It's presumed to be so. Paragraph 2. Sometimes a man and a woman. Okay, we will talk on the basis of non-same-sex marriages because it will be complicated, okay? So, a man and a woman might have a relation from before getting married, which is, I think, quite common nowadays. So, they might have a child. So, the woman might get pregnant before getting married. According to paragraph 2, if the child is born after 200 days from the formation of the marriage, again we have the presumption that it's the husband's child. Sometimes couples get divorced, so sometimes a child might get married after the dissolution of the marriage. If the child is born within 300 days after the dissolution, for example after the divorce, again we have the same presumption. Now, sometimes the father, the husband, might be a bit surprised. I was watching a movie with such a scene. The wife calls the husband on the phone and she tells him, you know, I'm pregnant. And he says, excellent, but I haven't seen you for a year, more than a year. How did this happen? And she says, well, you know, such things happen. Don't worry about that. So the issue is, do we still have the presumption? If we check the father's passport, we can see that he left Japan 2 years ago, and he was abroad for 2 years, which means that biologically the child cannot be his. Answer: no. In such cases, the presumption of Article 772 does not apply. Which means that we know who the mother of the child is, we don't know who the father is. Why is this important? Well, maybe the actual father of the child wants to do an affiliation, ninchi, recognition. So, if we had the presumption, we would first need to deny the presumption, to say that officially no, the child is not his, and then make the affiliation. The Japanese Supreme Court said no. The actual father, in such cases, can directly affiliate because we have no presumption. So he can directly say that yes, they are married, but he is abroad for 2 years. This child is mine, I affiliate, I recognize directly. because there is no presumption. Another issue is the second one. As I told you, sometimes children are born within 300 days from the divorce, for example. We have the presumption. The child is presumed to be the former husband's child. But, according to the Japanese practice, if you have a medical certificate, if you go to a doctor, he can tell you when the woman got pregnant. And he can make a medical certificate saying that she got pregnant after the dissolution, after the divorce. In that case, the presumption does not apply. So again, the actual father, with whom she was having a relation after getting divorced, can directly, for example, affiliate, etc. Any questions up to here? No. So, if you don't have any questions, I can make it a bit more complicated. Now, as I told you, if a child is born after 200 days from the marriage, it is presumed to be a child of the husband. A question I receive often from students. But if the child is born 100 days after the marriage? Answer: there is no presumption. Which means that even though they are married, the father needs to affiliate. He needs to say, we are married, the child was born during our marriage, but not after 200 days. I need to affiliate. Which feels a bit strange, doesn't it? You have a wife and a husband, the child is born after the marriage, but he needs to affiliate. He needs to say, you know, this child is mine. So, please take some notes, because it's not written on today's material. According to the Japanese courts, the same applies if the child is born after 200 days from the day the couple started living together in a de facto marriage. So, even before getting married, most couples live together as a couple. If the child, according to Japanese courts, is born after 200 days from the day they began to live together as a couple, we have the presumption, which means that the child is presumed to be the child of the man, the husband. So, if they started living together from a year ago, they got married after a year, and the child was born the next day of the marriage, this applies, because it's after 200 days from when they started living together. Who can explain that in Japanese? I will give you double marks, because I see that some Japanese students are like, ooh, what's that? So I need an interpreter. Okay, Matthew, could you try explaining that in Japanese?
一応同居してから、200日が経てばこれも含まれるということですね。同居してから。
Oh, Matthew, you have also reached the maximum for 3 lectures, you know that? You didn't? Okay, it's not 5, but so you are number 2, she's number 1, you're number 2 actually. So, any questions regarding this? You should have one question. You need to have one question because it's something that I need to explain to you, but I wanted you to feel like, how? So what's the question that you should have? I will give you some hints. You are working in the local authority. You are in charge of the registry, family registry. A couple counts. Are you married? Yes, we are. When? Yesterday. When was the child born? Today. The first thing you think is, oh, we don't have the presumption because it's only one day after the marriage. Then you ask them, when did you start living together? So what's the issue with that?
Whether or not they have records of living together, but when you move coup, you always have to put the head of the household and the other members of the family. So
Excellent. So, as Matthew said, you will feel like an important person. You will say, I did not become a judge, but now I feel like a judge. Do you have any evidence? Can you prove that? Can you prove that you were living together? Any photos? Any letters? Any emails maybe? But you are a public servant. You are just a public servant of the family registry. You don't have the power to ask them to prove. So, what's the practice nowadays? If the child is born after the marriage, they always apply this presumption. Why? Because they cannot check whether the couple was actually living together, whether the child was born 200 days after they started living together, etc. So, you need to be careful. Even though the provision is like this, in practice, if the child is born after the marriage, we have the presumption. They presume that it's the child of the husband. Why? Because they cannot check if they were actually living together, if they actually started living together 200 days before the child was born, etc. Any questions regarding this? It's something additional, but it's important. Yes, Kathleen?
The couple rebutted, right?
Sorry?
There's a presumption unless the couple is the other one. Or
That's a good question. So the husband and the wife go to the family registry. They try to register, but the husband said, she was having an affair anyway. So yes, the child was born after her marriage, but it's not mine. Well, that's a bit tricky. So I think, again, the public servant cannot check that. So as long as the child is born after the marriage, he will register it according to the presumption. And then, Kelvin, that's a good question. There is something the father can do. He can sleep and cry about the child. No, this is actually what I would like to do right now. I feel sleepy these days. I don't know why. Do you have the same feeling? Maybe it's what? Okay, maybe it's the Gogatsu-gyo. How do we translate that in English? May sickness. Wow. May sickness. Is it an official sickness? No. Thank you. So, and this is a movie I would like you to see it, to watch again. Are you watching the movies I'm showing you, or is it just a loss of time? Okay, Wikipedia. Have you seen it? Yes, it's a must. You should watch it. Giver. It will make you think about so many things. Philosophical issues. What is life? I know it looks like a love story between two young guys, but it's very philosophical because it's a novel written by a person who is a philosopher, I think. And yes, so it's really interesting. I strongly recommend it. You're not taking notes, so I'm moving on. So, now, the question is, Kelvin raised a very good issue. You go to the family registry, and the husband feels like, yes, but we were not having sexual relations with my wife, so it's not my child. What can he do? Let's have a look at Articles 774 to 778. Article 774 says, rebutting presumption of legitimacy. So in Japanese, jakushutsu no hinin. So the husband may rebut the presumption of the child in wedlock. Please be careful. He needs to do that 775 by an action, and he needs to do that 777 within 1 year of knowing of the child's birth. Which means that he only has 1 year. Why is that? Because otherwise there would be no stable and secure and safe family life. So we need to have the issues finalized during a short period of time, so it's only 1 year. And please be careful, Article 776. Who would like to read this article? Yes, please. So Maori? Maho, sorry, Maho. Okay. What's your, sorry, no, wait. So you are, okay, yes, sorry. Yes, please?
If a husband recognizes that a child is his child in wedlock after the birth of the child, he shall lose his right to rebut the presumption of legitimacy.
Oh, yes, sorry, Maho agreed, yes. So, Maho, according to this provision, if the husband recognizes that the child is his child, he loses the right to rebut. Question. Does he lose his right if he goes with his wife to the local authority and register the child as their child? Answer, no. Because it's an obligation. They have the legal obligation to register the child's birth. So only by registering you cannot say that he recognized it. There needs to be something additional. Don't ask me what. It depends on the case, because this is the provision. For example, we could think of a situation where he calls his friends, they're having dinner, and he says, you know guys, I know that it's not my child because I was abroad for 2 years. No, in that case we don't have the presumption. So, I know that my wife is having an affair, but I don't care because I love her, I love this child, so I will raise it as if it's mine, for example. Something like that. It depends on the case. Now, next issue. According to what I told you, if we have the presumption, the period of time is only 1 year. So after 1 year, everything is finalized. What happens if we don't have the presumption? In that case, if you have a look at Article 2 of this Personal Status Litigation Act, we are not going to read the provision. In Article 2, in Article 2, number 2, please underline the last part which says actions seeking a declaratory judgment on the existence of a natural parent-child relationship. In Article 2, number 2 of the Personal Status Litigation Act, please underline the last part which says actions seeking a declaratory judgment on the existence of a natural parent-child relationship. What's that? It's an action by which you ask the judge to say, yes, this is not your child, or this is your child. What's the difference with the other action? No time limit. You can do this theoretically forever. So, if your question was, what's so important with this presumption? Answer, if we have the presumption, everything is finalized in 1 year. If there is no presumption, even if a child is registered as your child, etc., for example, the husband has forever the right to say at some point of time, you know, actually this is not my child. So things are not settled, are not finalized. Now, so what happens if there is no presumption, if we don't know who the father of the child is? 779, a father or a mother may affiliate. 779. But as you remember, yes, the mother does not affiliate because she gives birth, so we know that she's the mother usually. The new information is that we have two types of ninchi. Affiliation according to the Japanese translation of the Ministry of Justice. It's also the same like recognition. I prefer recognition, but I will use affiliation anyway. Please have a look at 781. If you have a look at 781, it says affiliation shall be made through notification pursuant to the provisions of the Family Registration Act. Oh, again, you go to the local authority. You go to the public servant and you submit a document saying I'm the father. Registration, that's all. Paragraph 2 is quite interesting. You can also do that by will, which, well, for the male students, please don't do that because you make things so complicated. Because as you can understand, people will calculate the inheritance without taking into, without thinking about that child. So everyone will be surprised if you do that by your will. Things will change completely. Your wife will be happy. She will think, I'm the only heir. I will receive everything. And then she will need to give half of the property to the child. So you can easily understand that there might be a court procedure, etc. So it's better to do that when you are still alive. But sometimes you cannot do that because you're afraid of your wife, etc. So anyway. Okay. Now, 787. Action for affiliation. To answer a question of Matthew again. So, who would like to read 787? Yes, please. Yuki.
Article 787. A child is her lineal descendant who has a legal representative of is may bring an action for application, provided that this shall not apply if 3 years have passed since the day of the death of the parent.
So, Yuki, well, it doesn't have to do with you, it has to do with male students. Your child can ask for affiliation even after your death. So you can see that things are a bit complicated here. You can affiliate by will, and the child can also ask for affiliation after your death. And you can easily understand how complicated the situation will be with the inheritance issues, etc. Legitimation, what's that? This is very important, please be careful. As I told you, we have oh, this is annoying. Okay, so we have two types of biological children. Children in wedlock and children out of wedlock. If a father affiliates, the child is a child out of wedlock. So, if you use legitimation, it can become a child in wedlock. Two cases. Please have a look at Article 789. Please be careful. Paragraph 1 is a case when we first have an affiliation and then a marriage. So, father and mother are not married, the father affiliates, which means that the child is a child out of wedlock. If they then get married, the child becomes a child in wedlock. Paragraph 2, the other way around. The father and the mother are not married. The woman gives birth. They get married, which means that the child is still not his. He has not affiliated. They have just got married. If he affiliates after the marriage, case 2, paragraph 2, the child becomes a child in wedlock. So in these two cases, you can have a child in wedlock even though the father and the mother were not married when it was born. This is called legitimation. You already have this slide in lecture 6, the previous lecture, so you need to combine it with today's lecture. Why do we need the father to affiliate? He is useless anyway. I'm working, I'm rich, I'm an independent woman. I don't need him. Guess what? Your child can take the surname, can exercise the father parental authority, and maybe here support and inheritance. So that's a reason why maybe you should also ask for compulsory affiliation if he doesn't want to affiliate, etc. Any questions? Yes, Matthew.
Two small ones. First, you mentioned the rebuttal procedure for the presumption. Would there be a need to prove that there is no biological relationship through DNA testing?
Okay, yes, you also asked me about that. Thank you. So, the answer is, you can use any evidence. You cannot oblige somebody to have a DNA test, which means that if the person, if somebody says no, then you cannot oblige him or her, but maybe you can use that as indirect evidence, etc.
But with an infant, they don't have the refusal right, and as someone is being recognized as a parent, they could probably force a DNA test on the infant.
Well, still the person who has the parental authority has the right of representation, so she in most cases can say no, she has the parental authority.
And the second one would be, if there's a late discovery of non-biological relationship, for example through a blood test where the child has been discovered as AB but the father's O, which is impossible, can they rebut even after the year has passed?
No, that's a very good question. So, the purpose of this limitation of 1 year is to make things settled, to finalize the issue. So after this point, the legislator does not care about the existence of biological relation. Things are over. So the child is officially a child in wedlock and also under the presumption. Okay? So that's the difference with other children. In other cases, you could do that. But if we have the presumption, we cannot do that. It ends in 1 year. Okay? Any other questions? Yes, please. I need to remember your name. Was it Alicia?
It's spelled as CHUQINGYV.
And you told me to call you? You didn't. It's the first time?
It's the second time?
Yes, you told me to call you.
So suppose there's a situation where where the father recognizes that he doesn't have the biological relationship with the child, but he still wants to take care of the child. For example, can a child be affiliated to both his official father and also his biological father at the same time?
Okay, that's an excellent question. No, there can only be one father. So, if the child is, for example, under the presumption, then you first need to rebut the presumption and then affiliate. So you can only affiliate if there is no father registered. The only exception is, well, it's not actually an exception, but as you remember in this, this dog is so, yeah. So, as you remember in this case, you don't need to rebut. So the child is supposed to be under presumption, but the father was abroad for 3 years, so the biological father can affiliate without rebutting. He can do it directly. But I guess I'm only partly answering your question because no.
So you're saying like the child cannot be affiliated to different people.
Yes. So if a person affiliates, and then there's another person, which means that maybe the mother was very busy, etc. So let's say, okay, it's just a joke. So let's say that also somebody else comes and says, no, I'm the father. We need to use maybe this. So we need to file an action and say, you know, the first guy who affiliated, he's not the father. And if the court admits that, then the other man can affiliate. But you need first to rebut or cancel the affiliation. So you need to have a child who has no father registered. And yes, that's also a good question. As I told you, in this case, there is no time limit. So that's the importance of the presumption. If you have the presumption, it's 1 year, so the child is better protected. Yes, inheritance is another issue. We are going to talk about that during the second semester. Regarding inheritance, you can inherit from both parents. Yes, yes. Okay? So, it depends on the case, of course, but yes, the answer is yes. Family, the end, and also our lecture approaches to the end. We have 6 minutes. I will be really quick, and don't worry, we will continue also next week. So, what's the end of the family? We could say that family never ends, so family is a never-ending story. But usually, if somebody dies, then at least the family ends for him. So we will talk a bit about the issue of wills. In Japanese, igon. Students of the Faculty of Law, do not read this yuigon. As a law term, family law term, it's called igon, okay? Other students, you can read it yuigon, okay? There's no issue. Now, what can you do with a will? Affiliation. As I told you, male students, try to avoid this. Don't do affiliation. No, I mean, it will get things complicated, but it's your right to do it. You can designate a guardian. Why would you do that? Maybe because you are alone with your child. Let's say that your wife or your husband has died, you and your child, and you know that you're sick, you're dying. So you can leave a will which designates who the guardian of your minor child will be. You can do that. And you can designate the share in inheritance, which is usually what most people do, and which leads to long court disputes. Because people are married, they have children, but they also have a young lover. And before dying, they want to leave half of the property to, or more than half, to him or her. And that creates a lot of issues. We are going to talk about that during the second semester. 15 years old, you remember that. It's an exception of the juristic act. A will is a juristic act, but you can do it without consent, 15 years old. And just let me talk a bit about this and try to get you to the next lecture too, because we always have to do that. Oh, if you come to the next lecture, I'm gonna talk about my one and only Go-Con experience. Once I went to Go-Con, it was the first and last time. And it was a horrible experience, but it's really interesting, so I want to share it with you next week. So before starting with the lecture, please tell me you are supposed to talk about the Go-Con before the legal issues, okay? Thank you. So the other interesting issue is this. Will by holograph document. This is very interesting because you will see some elements of the Japanese culture. To be continued next week. Thank you very much. See you next week.